Welcome everybody to our webinar on libraries, copyright, research and development, which is the third in a series of 4 EIFL webinars that we've been running over the last couple of months on copyright and libraries. My name is Teresa Hackett. I manage EIFL's programme on copyright and libraries. Our webinar today is scheduled for 45 minutes. It's being recorded and we'll share the recording and the slides and the other materials afterwards. There will of course be an opportunity to ask questions after the presentation. So please use the Q&A function at the bottom of your screen and we'll keep an eye on the questions. My colleague Edwaldus behind the EIFL logo there will monitor and will help with the chat. So for our topic today, when it comes to copyright research and development, copyright limitations and exceptions, also known as L&Es, are fundamental. So L&Es are an intrinsic part of a healthy copyright system, and they're vital tools that enable creativity, innovation, access to knowledge, and access to educational materials. So EIFL advocates for robust mandatory limitations and exceptions so that libraries everywhere, and especially in developing and transition economy countries where EIFL works, can maximize access to knowledge and information for education, research and socioeconomic development. So I'm delighted today to welcome our expert speaker, Faith Majikalogbe. Faith is an assistant professor at the University of Alberta School of Law and a faculty associate at the Berkman Klein Center for Internet and Society at Harvard University. Faith is a scholar in IP and policy development, researching the role of IP and innovation, policies and practices relating to access to knowledge, including education, research, health and sustainable development. Faith also advises governments and international organizations on IP and development. She's a member of the Global Expert Network on Copyright User Rights and OpenAIR, which is the Open African Innovation Research Network. And then in April, Faith wrote a policy brief for the South Centre in Geneva, that's an intergovernmental organization of developing countries, on this very topic. So she is the perfect speaker for our webinar today. So Faith, over to you, and the floor is yours. Thank you.
Thank you very much, Teresa and the EIFL team for the kind invitation. And thank you everyone for joining this webinar from different parts of the world. Good morning from Edmonton, Canada. Today I will speak of 4 interrelated subjects: libraries, copyright, research, and development. And I have some slides, so I'll share my screen now. I'd like to start by stating that copyright as a property right is not an end in and of itself. Copyright is a means to an end. And right now it feels like people envision copyright as an end in and of itself, that the reason why we have copyright protection is really to give private rights over expressions of knowledge to people to proprietorize knowledge, as in the case of physical property. But that's not really the case. Copyrights, granting private rights over expressions of knowledge is not really intended to be for the sole proprietization of knowledge. It is designed to serve as an incentive for the publicization of knowledge, an incentive for other people to have access to knowledge. So privatization of knowledge, which is what we see today, which is what we see publishers and most big copyright corporations use copyright law for, is the very opposite of the objective of copyright law. For the encouragement of learning, those were the words that really heralded the first English Copyright Act, the Statute of Anne. So in other words, the Statute of Anne was really enacted to encourage seekers of knowledge, that they may continue to have access to expressions of knowledge from which they can search. And so learning and research were important, and access to learning and research was not to be impeded. And that's why the whole idea of copyright, at least from the Anglophone perspective, came into being, that people should not just write and keep those writings to themselves. Let's give them copyright protection as an incentive for them to publish this knowledge so that it could be available for people and people can continue to learn from these works of authorship. So where do libraries come in? Institutions of learnings and portals of knowledge like libraries predated the copyright system. They've been centers for the promotion of learning, and copyright law was designed to be an additional framework for the promotion of research and learning. It's designed to be one of those frameworks that we have. We have the educational institutions, we have libraries, but we also have copyright system as a system that should promote research, that should promote learning, and should promote the overall human development. So it was never designed as a framework that should impede learning or the works of educational institutions and libraries. The Statute of Anne clearly reflected this by requiring that rights holders must deposit 9 copies of each book in the best formats in and for the use of 9 libraries, public libraries in Britain. That was the framework within which the Statute of Anne was created. And so it was not intended to stand in the way of libraries. In fact, there were measures put in place to ensure that libraries continued to have access and that libraries could work together with the copyright system to ensure that people had access to knowledge. So in the same way that libraries provide access to knowledge that could lead users to produce more knowledge or use existing knowledge for that developmental purposes, the copyright system ought to do the same thing if copyright systems today are designed according to the original pattern in the English Statute of Anne. So copyright research and development. Research and learning are integral to even and sustainable development globally. There is a direct correlation between research and learning and each of the sustainable development goals. When we talk about people, even lifting people out of poverty, access to knowledge, access to information, access to education has been said to be integral to lifting people out of poverty, and people being able to have access to knowledge through libraries, through public institutions, especially when they can't afford to have access, would be very integral to people getting the kind of education that they need to be lifted out of poverty, especially in developing countries. In the area of food security, which is in this age deeply connected to access to clean water, to climate change and other environmental issues, having access to research on some of these issues is integral to developing solutions to food security issues that plague our world today. And in the area of good health and well-being, I mean, COVID-19 was a really big eye-opener. We saw our publishers were really forced to open up access to knowledge to ensure that we had access to existing research that could help us understand the coronavirus and could help researchers to think through how to develop measures that would be helpful to combating that virus. And access to biomedical literature is pretty much important to accessing to health users for them to promote health, and for people like you and me to even have access to journals in this particular area to understand certain things that are going on in the area of healthcare. The most connected area to copyright in the area of development is the area of quality education. A lot of us on this call are either educators or librarians or people in that particular space, and we understand the connection between copyright and access to knowledge for educational opportunities. And in the area of clean water, decent work, I could go on and on, but there are connections between access to knowledge, access to copyrighted expressions, and different areas of development. And so while copyright is not the only contributor to research and learning, and it's not the only contributor to these areas of sustainable development, copyright framework is still vital. It's a vital component of the promotion of research and learning. And also it's a vital component of the ability of libraries to actually facilitate research and learning. And so the copyright system, the restrictions on access and use affects whether people would be able to access and use materials, and also how they would be able to use those materials, and how they would be able to do important research that combats key global challenges, development challenges. So while copyright law has much developed from the times of the Statute of Anne, and we might say, you know, we are not in 1710 again. And so even though the Statute of Anne was designed for the encouragement of learning, a lot of people think like copyright systems these days are not really for that particular lofty purpose. They are not designed for the public interest. But really, even though we've developed away from copyright law, much developed from the times of the Statute of Anne, the scope of copyright protection is has far exceeded what was provided for in the statutes. The term of copyright protection is far longer than what we had in the Statute of Anne. The promotion of research and learning still remains at the core of public interest, sought to be protected by various copyright systems today. That the objective of copyright law encompasses the advancement of research, learning, and development is really still recognized and embedded in the copyright jurisprudence of most countries, whether it's through statutes or case law. For example, in Australia, you have the highest court in Australia noting that the social contract envisaged in the Statute of Anne still very much underlines the present Copyright Act in Australia, and that copyright is really an incentive for making a work available to the reading public. So it's not really an end in and of itself. Even in jurisdictions that are more leaning towards authorial protection, like in the EU, you have the InfoSoc directive in its preamble saying that the directive should promote learning and culture by protecting works. So the protection of works is really a means to promoting learning and culture, and it emphasizes the role of exceptions and limitations in the promotion of public interest, especially for the purpose of education and teaching. And most of us are familiar with the constitutional basis for copyright protection in the United States that highlights that the promotion of the progress of science and useful arts is really the end of copyright protection in that jurisdiction. We do that by giving authors protection for a limited time, but the end of copyright remains the promotion of science and useful arts. And in Canada, where I am based, we have the CCH and Law Society of Upper Canada. This is the case that declared that copyright limitations and exceptions are user rights in Canada and should be protected as such. You have the courts noting that the Copyright Act presents a balance between promoting the public interest in the encouragement and dissemination of works and obtaining a just reward for the creator. So there is a balance to be struck, and that's the aim of copyright is really to promote public interest, and it's done in these two ways. While international intellectual property instruments do not have as much limitations and exceptions and mechanisms for promoting the public interest in copyright law as we do find in domestic copyright laws, we still have key international instruments recognizing the role of copyright in advancing development, in advancing research. You have the TRIPS agreement, which is the most important multilateral intellectual property agreements today, recognizing that the underlying public policy objectives of national systems includes developmental objectives. And even in the objectives and principles of the TRIPS agreement, you could see that the protection and enforcement of intellectual property rights, including copyrights, ought to be for the advantage of both the producers and users of knowledge, and should be protected in a way that is conducive to social and economic welfare. So you see all of that coming from international copyright instruments. You see the WIPO Copyright Treaty, talking about the need to maintain that balance between the rights of authors and the larger public interest in education and research and access to knowledge. And we see the first copyright statutes that has mandatory minimum limitations and exceptions, the Marrakesh Treaty, really emphasizing that copyright protection is meant to be an incentive, and that incentive should lead to enhanced opportunities for everyone to participate in knowledge, to enjoy the arts, to share in scientific progress. So that brings us to limitations and exceptions. The main way in which copyright law ensures that the grant of copyright is not directed towards privatization or monopolization of knowledge, and that the grant of copyright law does not defeat the social contract underlying copyright, is really through the mechanism of limitations and exceptions. Limitations and exceptions permit uses of copyrighted works that would otherwise not be permitted, that would otherwise be excluded by copyright owners during the time of copyright protection. So by permitting those uses, limitations and exceptions really limits the scope of uses that we would require the permission of copyright owners to engage in. And the mechanism of limitations and exceptions is recognized in domestic, regional, and international copyright instruments. I mean, when we are looking at the international copyright instrument, it's less integrated. We have the 3-step test that provides this framework for limitations and exceptions that recognizes the fact that countries would have limitations and exceptions in their domestic copyright instruments, but does not really delineate a lot of those exceptions. I mean, we have the mandatory quotation exception in the Berne Convention, but in other international instruments, we don't have a list of mandatory exceptions. We have few permissive exceptions in the Berne Convention, like the exception for teaching. But in the Marrakesh Treaty, we have a list of mandatory exceptions for visually impaired persons. And then we have this 3-step test framework where countries use that particular framework to design their own limitations and exceptions in domestic copyright law. So even though it's less integrated into the fabric of international copyright law in the sense that we don't have a lot of mandatory minimum exceptions that are of general application, copyright exceptions are recognized in most national copyright laws as an integral part of the copyright system. It is unlikely that you'll find a copyright act without limitations and exceptions. They might not be as broad as we want them to be, but they are recognized as crucial parts of our national copyright systems. Many of these limitations and exceptions allow for uses that would otherwise not be permitted during the copyright term. And limitations and exceptions, which we would usually call L and E's, could be general. It could relate to works, generally every type of works that are protected by copyrights, or it could be general to users in the sense that any kind of person could use it. It might not be restricted to maybe students or persons with visual impairments. So you have examples like the fair use and the fair dealing exceptions. They are general exceptions, but you also have specific exceptions that are specific to works, that are specific to users or certain uses. So you have limitations and exceptions for libraries, for instance. Some jurisdictions you would find limitations and exceptions for educational institutions, limitations and exceptions relating to computer programs. They are pretty specific. Are not as broad as, say, the fair use and fair dealing exceptions that you might find in some jurisdictions. And different jurisdictions also opt for different models for their limitations and exceptions framework. So you find open-ended general limitations and exceptions like the US fair use that is really not restricted to certain purposes, that allows people to use works as long as it constitutes fair use and the fair use factors are analyzed. But you also have more close-ended general L&Es that are not specific to certain users, but are specific to certain purposes. So for example, in the UK and in Canada, you have a broad general L&E framework, the fair dealing framework, that restricts the application of the fair dealing exception to certain uses like education, research, parody, and things like that. So you have this closed list of uses or purposes for which you could use that general exception. But you also have models like the enumerated specific L&Es, like in EU countries where you have specific L&Es for specific purposes, and you have jurisdictions that use a combination of both. For instance, in Canada, even though we have the close-ended general L&E, the fair dealing exception, we also have a set of specific enumerated specific L&Es that we use in combination with the close-ended general L&Es. So to the extent that limitations and exceptions permit access and uses of works, for purposes connected to research, whether through open-ended general L&Es, closed-ended, enumerated, or a combination of both. Limitations and exceptions are vital to development. And so for many learners and researchers, when we look at what's the connection between libraries and copyright exceptions, for many people, libraries are really the gateways for the exercise of limitations and exceptions. In most cases, the limitations and exceptions that we have are use exceptions in the sense that they don't necessarily grant us the initial access to the material, but they tell us what we can do if we have lawful access to the materials. And so in most cases, people do not purchase their own materials, or they do not purchase all the full range of materials that they need to access. And so they rely on public institutions like libraries to get that lawful access, and then use their limitations and exceptions, their user rights, to actually do certain things with those materials. So if they get a copy, access to a copy in the library, then maybe relying on the fair dealing exception, for instance, they could make a copy of a certain number of pages that they require for teaching purposes, for research, for any other purpose. So in that sense, libraries are gateways to the exercise of limitations and exceptions. People rely on the collections of works in libraries to exercise their user rights. And so we find that what libraries can do in this day and age are restricted by copyrights, are restricted by contracts, publishing contracts, licensing contracts. You also have technological measures that really restrict what libraries can do. And to the extent that we have all of these restrictions on what libraries can do, on when libraries can make copies for preservation purposes, on when they can engage in interlibrary loans or engage in digital lending. To the extent that we have all of these restrictions affect individuals. They become restrictions on end users. So you may have robust L&Es for end users, but if you don't have robust limitations and exceptions that allow libraries to continue their traditional functions of being portals of knowledge, you would, at the end of the day, have restrictions on end users. It would impede research and learning, and consequently development. So it's not enough for us to have limitations and exceptions for individuals that can be enjoyed by individuals. We must also have limitations and exceptions that can be enjoyed by institutions like libraries, like archives, museums, educational and research institutions as well. L&Es have become very important for libraries, especially in the digital age where we have greater exclusive rights. You have contracts that sometimes restricts what libraries can do. You have technological tools that also monitor what libraries can do and further restricts how libraries can distribute materials and the channels of distribution. And all this combined together make it more difficult and even more expensive for libraries to provide access to copyrighted works for research purposes, thereby threatening the core function or the core functioning of libraries today. So to promote research and safeguard the important roles of libraries as portals of knowledge, as institutions that really facilitate access to knowledge for research purposes and consequently for developmental purposes, and even to prevent librarians from being crippled by copyright anxiety, which is something that we are finding more and more within the library community. Institutional copyright L&Es must be expanded. We must not just have, copyright limitations and exceptions for individual users. We must begin to think of having broader copyright limitations and exceptions for institutional users within national and international copyright frameworks. And some of the relevant ones for libraries include provisions that permit preservation activities, especially in the digital age, being able to preserve materials in formats that could be accessible later is pretty much important for libraries, and it involves doing certain things that could constitute copyright infringement. And so having exceptions that allow libraries to engage in preservation activities would be important, as we are faced with more disruptions in climate and materials collections and libraries are being destroyed by natural disasters. It's becoming more important that libraries are able to preserve knowledge for existing generation and future generation. Limitations and exceptions that permit interlibrary loans are important. Not all libraries would be able to buy the full range of collections that their users or their patrons need access to. So for libraries to be able to engage in interlibrary loans, that would be important for people to be able to access the broad range of materials that they need to conduct research and to tackle the developmental challenges that face us today. And digital lending is something that is huge. Libraries have always been public lenders, and that particular role that libraries play as being lenders of materials is really being challenged today by the various models of distribution of works that publishers have adopted today. And so for libraries to be able to engage in controlled digital lending, we might need to have more creative limitations and exceptions that permit libraries to engage in these particular activities. We might need to have to develop a broader system of digital exhaustion than what we have right now, extending the first sale exception or first sale doctrine to the digital age. Circumvention of TPMs would also be important. The libraries are able to circumvent TPMs for non-infringing uses, would be important to libraries really continuing to function as portals for knowledge. And contract override prevention clauses are pretty important, even though in many jurisdictions, especially in Canada, user rights, copyright limitations and exceptions are recognized as user rights, and we have pretty much a really good Supreme Court of Canada decisions, that back up the use of limitations and exceptions, and contracts should not override those limitations and exceptions. But libraries and library communities would feel safer when they have copyright override prevention clauses that really stop publishers from undermining exceptions and limitations that are put in place by legislators for the protection of libraries and for the full functioning of libraries. And I have here the recognition of general exceptions as applicable to libraries. That's very important because even though we might have a range of specific enumerated limitations and exceptions that libraries could take advantage of, having broad limitations and exceptions that libraries could also take advantage of is important as technological means of distribution and access to works really expand and really changes rapidly. It would be important for libraries to be able to have general exceptions that they can rely on when specific exceptions do not cover the kind of activities that they want to engage in. So general exceptions like fair use and fair dealing, in some jurisdictions, they are deemed to be individual exceptions, and libraries are really not able to creatively rely on those exceptions to be able to do some things that may not be covered by specific exceptions for libraries. But it would be important to recognize those exceptions as applicable to libraries and other institutions like educational institutions. In Canada, for instance, the Supreme Court of Canada has consistently applied the fair dealing exception as both an individual exception and also as an institutional exception. So most libraries in Canada and educational institutions in Canada have successfully relied on the fair dealing exception to counter copyright infringement lawsuits by publishers. And LNEs for libraries must also be technologically neutral. They must be designed in ways that they can keep up with technology to ensure certainty regarding the application of LNEs that were enacted in, say, the pre-digital age, or even LNEs that were enacted in digital age, but did not take into consideration some of the digital advancements that we have today. So if we don't have LNEs that are technologically neutral, libraries would not be able to fulfill their roles in the digital age, and libraries would struggle to lend and preserve important materials. And these two activities are really integral to the mission of libraries. And so lastly, I want to talk about the internalization of LNEs. Having global minimum standards for limitations and exceptions for libraries is pretty important. And I know IFL has been working a lot in this area, as Teresa mentioned in her opening remarks. Having global minimum standards for limitations and exceptions is important to facilitate cross-border research and learning and to reduce global access inequalities that fuel developmental inequalities. So efforts to do this must continue at the World Intellectual Property Organization and the Standing Committee on Copyright and Related Rights, where IFL is doing such great job to push for limitations and exceptions for libraries. By having minimum mandatory exceptions all over the world, we can at least rely on basic minimum benchmarks that libraries can expect to have, regardless of the country that the library is based. And having minimum mandatory L&Es also gives libraries the certainty that they need to undertake activities that are cross-border. And research is increasingly cross-border in this digitally connected world. And so without assurance that the same exceptions will be recognized in other jurisdictions that libraries are trying to connect their patrons to, it might make it difficult for libraries to continue to continue to perform their functions in an increasingly cross-border world and to support cross-border research in this world. So it's important for us to continue that work at the WIPO SCCR and to continue to push for limitations and exceptions for libraries, global minimum standards for libraries, to ensure that all libraries all over the world can at least rely on a minimum benchmark of limitations and exceptions to continue to function as important portals of knowledge. So I'll stop here and I would take questions and engage with the audience. Thank you, everyone.
Well, thank you very much, Faith, for that brief tour of the background and the policy issues connected with limitations and exceptions. And I like that you began by showing how the exceptions are rooted in the international treaties, because sometimes, it seems like the exceptions and limitations are kind of a poor cousin of the copyright system, because you have the exclusive rights are international level and they're mandatory, they're exclusive, and they're but the exceptions are for the most part optional and left to the national level. But we can see when we do have mandatory exceptions in international treaties, it has a huge impact. We could see that from the Marrakesh Treaty for persons with print disabilities. And that has had a really tangible effect. So now countries all over the world are introducing exceptions for blind and visually impaired people. Why? Not because there was a huge sudden great interest in this topic by policymakers all over the world. It's because the Marrakesh Treaty was there and adopted, and there was an incentive for countries to adopt these exceptions. So we know that having mandatory exceptions are important. And of course, when we're speaking in a webinar like this, it's of necessity. It's an international event. So we're speaking at a kind of a high level, talking about treaties, and then to some degree, how the exceptions look in national copyright laws. I put a link into the chat there on a WIPO study on exceptions and limitations for libraries and archives, where you can see what do the exceptions and limitations look like in general in your own national copyright laws. Now, the study was done by Professor Kenneth Kruse, and the last update was in 2017. So it's a couple of years ago, but as we know, copyright law reform takes time. So while a number of countries have updated their limitations and exceptions since the study, an awful lot haven't, and there is still a lot more work to do. So if you would like, want to see more about the detail in your law, I recommend that you check Professor Kruse's study as a starting point for that. So we have one question, Faith. We have a question in the Q&A, which I think is interesting, and then I know it's a topic that you've been working on, so you'll be well placed to answer it. So the question is, in journal publishing, why do our institutions and universities allow researchers and faculty to hand over their rights to the publishers, and then it becomes the copyright of the publishers and the paywall barrier on access to research. So that's actually a topic that we are working on together at the moment with Faith. So Faith, I'm going to let you take that. Thanks.
Thank you. So I'll start by saying that it's not really as if our institutions allow us to relinquish our copyrights to publishers and distributors. Usually in most countries, you have the principle of academic freedom, and you have the principle that copyright stays with the authors of journal publications. And oftentimes when we go to the bargaining table, when we want to publish, we really have little to no bargaining power. So usually we have no choice in most cases than to relinquish our copyrights. Now we have like platinum access journals, but in most cases, most journals are hybrid journals or closed access journals. And so in exchange for publishing our work, they would want to have copyright protection in that particular work. And so in most cases, we relinquish copyright in that particular sense. Now, what most jurisdictions could do, or what most universities are doing, is to have open access policies that require academics to publish in either open access journals or gold open access journals, or to make their accepted authors' manuscripts available on digital and open repositories and publish there. But oftentimes the issue with that is that, again, we've relinquished copyright protection to publishers, and in most cases we have embargo on when we can put that up on, say, SSRN or on our institutional repository. And so if we have a situation where, we have a rule that says, oh, you can't relinquish your copyrights to publishers, even if our institutions have that, it would be really difficult to enforce, because what would happen is you would have a limited number of outlets in which you can publish in, because we still have a large number of closed access journals or hybrid journals. All our institutions would have to be willing to pay what we call article processing charges for us to be able to publish on an open access basis without relinquishing our copyright. Now, that's very expensive for institutions. Most institutions can't cover the full range of article processing charges. Most institutions are covering, certain percentages, entering into agreements with publishers to cover certain percentages, but it's really expensive for institutions to do that. And so if they have those mandates, we won't be able to publish in places that we want to publish in as academics. And at the same time, they would have to put money up front for us to be able to pay article processing charges, which can be expensive. So what Teresa was saying that we are working on, in some jurisdictions in Europe, you have what is called the secondary publishing right that is built into the Copyrights Act to ensure that when academics or researchers publish their work, especially publicly funded research work, they retain the right to publish it, to republish such work on openly accessible platforms like SSRN or institutional repository. And that's what we're really pushing for all over the world, for that to be integrated into copyright systems.
All right, thank you, Faith. And I've put a link into the chat there with the guide, a page that IFL has on this issue of rights retention. So encouraging academics and researchers to retain their rights, and indeed the issue of retaining rights is now often mandated. It's part of the grant funding process. That authors do retain their rights in order to then be able to keep those rights so that they can share their work later on an open access basis. So Faith, there's another 2 questions come in, so we'll deal with those. First of all, first question is about publishers and collective management organizations have a dedicated lobbying staff and budgets to keep pushing against the expansion of exceptions. What can we do if we don't have those budgets and roles? And then how can we justify fear use, or how can we justify use without fear of copyright infringement? I mean, perhaps just on the first question, I can mention that yes, of course, the publishers are well funded and do have lobbyists and are well lawyered up. But we also have advocates and you know, a lot of people and who do engage at the international level, and that's why it's very important that we as librarians professionally engage at a national level and also at the international level at WIPO. And we represent the public interest. We represent institutions that serve millions of students and researchers and teachers all over the world, and that's a very important role. And so we also have good arguments on our side, and policymakers really appreciate hearing from librarians and hearing from the public interest, because they often only hear from the rights holders and the industry lobbyists. So they do very much appreciate hearing from us. So that's would be my contribution to that answer. But Faith, perhaps you might have something to say, and also then on the question about fear and copyright infringement.
Yeah, I would say, like, for libraries working together in association with one another, I know that, like, for instance, in Canada, we have like a strong association of libraries working together to make policy recommendations and for advocacy. So that would be pretty important for libraries to work together in association with one another if you're in a particular jurisdiction. And, you know, we also have groups that are supporting libraries and educational institutions at international level. And so working with groups like IFEL would be important to international advocacy as well. So while publishers have like lots of money, we also have public interest organizations that are really backing up access to knowledge. And so connecting with those public interest organizations would be important for public interest advocacy in the area of copyright limitations and exceptions. In terms of copyright fear or anxiety, which is really real, and Amanda Wakaruk here at the U of A and some of our colleagues are working on the issue of copyright anxiety. I'd say for librarians, really relying on what you have in your copyright statutes is important. A lot of times I find that like people have these robust limitations and exceptions, but because of the messaging of, you know, copyright being exclusive rights being the be and be all, people feel like even though they have these limitations and exceptions, they can't really rely on it. Even though this is not legal advice, but if you have limitations and exceptions in your copyright statute, starting from there, relying on it, knowing that those limitations and exceptions have been put there for the advantage of libraries, for the advantage of users, is pretty much important as a starting point. And also looking at, you know, the court decisions. There are countries where courts have really been very innovative in recognizing user rights and recognizing what libraries can and cannot do. And so relying on that, knowing that, you know, there are statutory provisions and court decisions backing up libraries would be very important. So relying on what you do have in your statute is a very good starting point to overcoming copyright anxiety or copyright fear.
Mm-hmm. Thank you, Faith. Yeah, copyright anxiety is a big issue, but I think another way to overcome that is also to get informed, be knowledgeable. Knowledge is power, and you know that also helps. And I think one other issue that we also support and we've been working on to help alleviate these issues of copyright anxiety is to have a limitation on liability for libraries and other institutions that are acting in good faith within an exception or limitation to the best of their knowledge. It is one of the few professions, really, if you think about it, where library professionals, library staff who are not typically professionally trained in the law, every day need to interpret and understand the law when you get questions from students, and you sometimes have, and faculty, and you have to do this quickly, and you have to maybe do it, you know, there's somebody standing on the other side of the desk and they're asking you, you know, can I do something or not? And so having that limitation on liability could also take the hard edges off, that if you are acting in good faith and to the best of your knowledge, you have given, you are acting within an exceptional limitation, that you are shielded. You have a sort of a safe harbor. And that is, we have precedents in some countries, including in the United States. So that would be another thing that we would advocate for at national level, to have a limitation on liability to help with those issues. So I'm looking at the clock, and the time has gone very quickly now, and it is 1:45. So we'll be closing now in a minute. I have put some links into the chats for some other resources that I encourage you to take a look at. So we have Faith's policy brief for the South Centre. We have a chapter in the IFLA publication on navigating copyright for libraries, which is about why libraries need limitations and exceptions. It's available online in open access. And then there's also an EIFL page on copyright limitations and exceptions and what is the EIFL position, that kind of also explains these issues in a nutshell. So we will be sharing all of these resources and the recording and Faith's slides afterwards. And then I also invite you to register for our last webinar in the series, our fourth webinar in the series next week, on this same day next week, the 23rd of October, which is on a topic that Faith mentioned, which is fair use, fair dealing, and fair practice. So what's fair in copyright? So we'll do a deep dive into what's fair in copyright, and we'll look at in a little bit more detail what are the similarities and the differences between fair use and fair dealing. And we encourage you to come along. We'll also have an extended Q&A during that session, where you can ask us questions about anything related to copyright and libraries, of course. So it could be on fair use, fair dealing, it could be on limitations and exceptions, our topic of today, or it could be on the previous topics that we had our webinars on. So whatever you would like, we will do our best to answer those questions. So we're looking forward to that last webinar in this current series. So Faith, with that, I would like to thank you very much for getting up early, for giving that nice presentation. I'd like to thank everybody for being online, for logging in, and we will be sending you all the information afterwards. So thank you, and bye-bye from Dublin.